Hello and welcome to the Rogers Brief for January 5th, 2024. Happy New Year. This is the first show of 2024. Glad to be back after a nice little holiday break. I hope everybody enjoyed their Christmas break and New Year's celebrations. Some downtime, perhaps, time with family and friends. It was the case for me. Take a little bit of time off to rejuvenate, relax, read some books, get to see some people too, which is nice, especially talk to a number of fans of the Rogers Brief over the holidays and of the Sunday night show as well, people that are listening in and tuning in on YouTube. So thanks for everybody for saying hi. And well, let's get back to it. We've got lots of stories to cover this week and a few just sort of holdovers from the Christmas break that I want to get to. And for those that are new to the show, new to the show in 2024, maybe it's your New Year's resolution to listen to more legal-themed podcasts. Well, what I do is I cover stories in the news that have a legal focus, a legal angle that maybe is a little underappreciated or maybe I feel isn't quite understood properly, and try to explain those things to you. Started off with the mass casualty inquiry in Nova Scotia. I look at some other inquiries. I'm going to be talking about one of those today. And other cases, sometimes with a Nova Scotia focus, because I'm a lawyer based in Nova Scotia, and so these are some of the cases I'm more familiar with. All right, so today I'm going to be talking about a few Nova Scotia cases, one being, well, it wasn't a case, but a decision by the RCMP not to charge anybody with the Tantallon fires, the fires that took place outside of the city of Halifax last summer that took many homes and many acres of forest. Interesting case I want to talk about, also a Nova Scotia case. This was a teacher who was charged with sexual assault, put on leave for a few years, finally got to trial, got a decision on that. And so I'll talk about that and some of the background. The foreign interference inquiry, federal inquiry into election interference allegations by state actors from China, Russia, that is getting underway soon, and so I'll cover some of that, including a request by the Conservative Party to an appeal, in a sense, of the decision from Justice Hogue not to give them full party status at the inquiry. And finally, I want to talk a little bit about south of the border. This is just fascinating. I'm reading more on this over the holiday break about the various cases that are going to end up in the Supreme Court of the United States dealing with the presidential election, the eligibility of Donald Trump to run in those elections. So I'm sure you've heard about these in the news. I'll give you a little bit of a perspective on that as far as I can tell from my analysis of the U.S. legal system and how that's all going to likely unfold in the next couple of months. So I'll get to that at the end. A couple of things to start with. One, this is, like I said, January 5th. 2 days ago marked the 7th anniversary of the deaths that led to the Desmond Inquiry, the Lionel Desmond Inquiry, which I was involved, of course, representing the personal representative to Corporal Desmond, his sister. So Corporal Desmond, his mother, daughter, and wife all died on January 3rd, 2017. Still awaiting the final report. Those would be familiar that last summer, the Provincial Department of Justice removed Judge Zimmer from the case. There's a story behind that, of course, so I won't get into all that now. Replaced it with Judge Paul Scoville, and we're still awaiting that report. Interestingly, I got a call today from a reporter from Saltwire asking about this, and he spoke to the Department of Justice. I, as lawyer to the family, have not heard anything from the Department of Justice, but the reporter called them today. They get word that the report should be ready soon, that it's in the final stages and should be ready soon. So we'll look for that in the next, I take that to mean a month or two. So we'll see, and there'll be an announcement apparently when that is ready to be announced. So that's one thing. Another thing, draw people's attention, if you're interested in forensic psychology, Dr. Margo Watt, a professor at St. FX, professor of forensic psychology, has published a book of cases. It's just cases in clinical forensic psychology. So she wrote a really nice chapter, and she shared it with me last year about Gabriel Wortman, the mass shooter in Nova Scotia. And I thought it was the most incisive piece of work on the psychology of Gabriel Wortman than anybody had come up with. And this, including all the experts that went to the mass casualty inquiry to testify. So really recommend this. It's an academic work, but the writing in it is really good, easily accessible. And I see in their other chapters, which I haven't read yet, that she discusses other cases, prominent cases you'd be familiar with. Dennis Oland, Russell Williams, the mass shooter, ex-military mass killer in Ontario, Karla Homolka, Tori Stafford, the Donald Marshall, Colton Bushy cases, and others. So lots to dig into there. Accessible price-wise too, no more than a regular book. I think a hardcover is 40-something, and the softcover is 30-something, or the ebook. So an accessible piece of work for people that are interested in that. Dr. Watt, I would just say, I compare her to coaches in the professional sports. You'll sometimes hear of a coaching tree of, a Bill Belichick or somebody who's coached with Glenn Sather. Now all these assistant coaches are now head coaches in other organizations. Well, Dr. Watt is that equivalent in academics, in forensic psychology, and many of her students have gone on to academic careers of their own, and so has really done a service to the field of study. Third quick thing just before we get started into the cases is Dennis Edney. Dennis Edney might not be a familiar name to everybody, but he died this last week at the age of 77. Dennis Edney was the lawyer for Omar Khadr. Omar Khadr, the Canadian teenager who was arrested in Afghanistan, detained in Guantanamo Bay, subject to torture and all kinds of terrible things. Pretty scant evidence of him having done anything in Afghanistan that would have justified any of this treatment. Anyway, Dennis Edney was who won national awards for his pro bono work. Represented Khadr, traveled to Guantanamo Bay, represented him for many, many years. When Khadr finally got parole, Dennis Edney, and his wife took him into their home in Edmonton, where he stayed. Dennis Edney, originally from Scotland, from Dundee, didn't become a lawyer until he was 40 years old. I think drove a truck and did some other jobs prior to that, and then became a lawyer, and then really exemplified the best of the profession. He spoke a few years ago at a Canadian Bar Association conference in Halifax, had the room in tears at times, and it was a rapt audience, huge ovation at the end. Quite a guy, quite a loss. So Dennis Edney, just wanted to mention that. Okay. Talk about some cases. Just in the news this week, I see the case that is not a case is the Tantallon fire. No arson charges laid. Community very upset. 200 homes and buildings lost. 800 hectares of land. There was a video apparently circulating that purported or seemed to show what might have started it all, but the location was uncertain. The people involved might not have been all that certain either. So the RCMP did some investigation and then closed their case, and that was that. Problem was, the RCMP didn't announce that they weren't going to proceed with charges. They just didn't, and they apparently told the Minister of Natural Resources, but didn't tell the public, didn't tell the community group that's been involved and been quite active. And so people are quite upset about that. And anyway, just people that follow this podcast on the Sunday night would not be terribly surprised that the RCMP didn't effectively communicate to the public some actions and some decisions. I think people would understand the decision. Very tough to prove an arson case such as that in the middle of a heat season. I mean, yes, there was no lightning, and maybe it started accidentally, or probably not on purpose, maybe accidentally, or maybe negligently, whatever, right? People can understand that it's difficult to build an arson case, but the RCMP should have come out, had a press conference, announced that that was their decision, and everybody can move on, ask the questions they want to ask, and continue on with other aspects of trying to figure out how to mitigate against future fire damage. All right, case out of the Valley that caught my attention this week. I didn't see it, didn't really get any news coverage. I didn't see, but I thought it was indicative, I guess, in a way, of the culture in which we find ourselves. This was a teacher. His name was Jason Pleasant Sampson. Don't know much about him. I know he's a baseball player, played for the Wildcats, teacher, and a trained first aid responder, provider. One of two in this school. Actually, it's funny, the decision doesn't name the school, but it's a high school. It's grade 9 students, so I assume Horton, but maybe not. Somewhere down there in the valley. So the allegation was that in June of 2019, June 14th, 2019, a grade 9 student was out rollerblading, got a road rash on her outside of her right leg, was taken by the gym teacher, Mr. Vino, to Mr. Pleasant Sampson, and he applied first aid, treated the wound. It was superficial wound, some bandages, and off you go. Two of her friends with her. They don't name the girl. GL is her initials, the initials that they use. So GL and two friends go to Mr. Pleasant Sampson's space, wherever he is. The door's open to the hallway, and a few minutes later she's gone. Well, what does she allege? She alleges some weeks later that, more than weeks later, that he had brushed against her privates, her vagina, and her buttocks with his hand that had paper towel on it. All right, the wound was on the outside of her leg. So, okay, Mr. Pleasant Sampson is put on leave. He's put on leave by the school and was on leave until this trial, until this decision. The girls claimed, the girl and one of her friends claimed that they went to the guidance counselor that day. Then they said it might have been a few days later, and spoke to the guidance counselor and said, well, here's what happened, here's the allegation, and you should do something about it. And they said the guidance counselor shut them down, did nothing about it. Well, here we have Judge Vanderhoek has a decision on the matter. The girls testified, the three girls testified, the guidance counselor testified, and the Mr. Pleasant Sampson himself testified. The guidance counselor, who is not friends with Mr. Pleasant Sampson, just colleagues, hadn't spoken to him since, said the girls did not speak to her, did not come ask for a meeting, and if they had, she would have, sent it up the line as per procedure. Judge believes her. So that was a big problem in their story. The other one was the complainant herself apparently was quite confident on the stand, but the friend was nervous, shaking, all those things that certainly caused some concern for the judge. The other thing that the judge noted was the allegation was that Pleasant Sampson was rubbing the wound, and the judge says if anybody that knows anything about first aid would know you don't do that, because you're just going to rub dirt into the wound. You would pat the wound and all those things. Plus, it was only a couple minutes. Pleasant Sampson testified himself. She had no problem believing him. It seemed, anyway, like a very easy decision to make in a way, okay? So what this raises, I wonder how long has Mr. Pleasant Sampson, first aid trained teacher, been on leave? And for what? It seemed like, so the judge's conclusion was that this girl just wanted to make a complaint against him, concocted the story, and convinced her friend to go along with it. The friend was nervous, was ready to lie, but very nervous about doing so, and didn't do a good job of it. And that was that. So it makes you wonder, all right, so how many steps would this have gone through, right? So the girls complained. So as soon as they go to the police lay a charge. As soon as the police lay a charge, the school has to act. They put the guy on leave. All these steps are taken without anybody really, it seems, assessing the story until it gets to a judge. So this happens. You see this many times, right? The police don't really want. All right, they don't want to make a real decision. It's a sexual assault allegation. They have to take it seriously, so they lay the charge. The Crown prosecutor. It's a sexual assault charge. They don't want to just drop it if the person is asserting that yes, it happened, even if it seems unlikely and all those things are unbelievable, then it goes to court. So all this time, the not guilty, Mr. Pleasant Sampson, is suffering, and his reputation is suffering, and it's a good teacher perhaps taken out of the system. So there's a problem there somewhere. Hopefully this exoneration, and it's a full exoneration. Judge Vanderhook believed Mr. Pleasant Sampson, who testified, and anyway, hopefully his reputation is secure and restored to the extent that it was ever harmed. All right. Next, I want to actually talk about, there was this is across Canada. I'm going to talk about the foreign interference inquiry and the Trump case as well, but I have a little bit of time. We got a notification from one of the judges about the new bail reform. So the C-48, the bill to reform bail in Canada, if you followed the news, you'd realize bail was a bit of an issue politically last year, and the government brought in some measures. So there are some changes coming, and they're going to be significant. So the judges wanted the lawyers who deal with these matters regularly to be aware of it, and one of the judges was kind enough to prepare some sort of a short summary of everything. So the main changes are reverse onus provisions. So what does that mean? Instead of, normally if somebody's charged, the default position is you get to, all right, here's your court date, you get to go home and no restrictions, unless the Crown can justify imposing those conditions. The reverse onus is, if it's a certain charge, certain seriousness, then you're presumed to be in custody unless you can prove that you should be able to get out, if you're safe to be out in society. So it is significant, and it gets, it's a significant alteration if you're one or the other. So the list is now expanded, which provisions in the criminal code are reverse onus. So it includes things like possession of prohibited or restricted firearms with ammunition, break and enter to steal a firearm, robbery to steal a firearm, making an automatic firearm, and weapons trafficking, or possession of weapons for the purpose of trafficking. So these are also importing unauthorized weapons. So a lot of these have to do with firearms. The second sort of major focus is on intimate partner violence. And so if you have an act of intimate partner violence, if you've been previously convicted of an offense an offense where violence was used in an intimate partner situation, and then now, instead of presumptive bail, you're presumed to be in custody unless you can show you deserve bail. So those are the two big ones: firearms and intimate partner violence. The other change is the reverse onus if you've had a prior violent offense that included a weapon. But in that case, both the current offense and the previous offense have to be offenses for which there was a 10-year, a maximum sentence of 10 years or more. There'll be a practical issue here, because when you get a criminal record of somebody, you don't know how. So when a charge comes before the court, the Crown has to decide whether they're going to proceed summarily or indictably. Summarily is less serious, indictably is more. And summary conviction offense, the maximum sentence is 2 years. Indictably, it can be life in jail, but it can be much more, right? 10 years. So, but on criminal records, when you just see somebody's criminal record, you know what kind of a sentence they may have received, but you don't know, just looking at the record, whether the Crown proceeded summarily or indictably, unless the sentence is more than 2 years, in which case obviously it was indictably. So there'll have to be some adjustments there just on bail situations so people will know how to treat those. Other things that are changes, they're required to consider any previous convictions involving violence. Well, they already do that. And a special consideration for Indigenous offenders and over-incarceration of Aboriginal accused or vulnerable populations. Well, again, that's kind of already done as now. Well, it is already done. Safety and security of the community is specifically has to be considered. Well, that is always considered too under the current test for bail. So there are some significant changes, and so it'll adjust the way bail hearings are held. All right, foreign interference inquiry. This one is the hearings are going to start on this late January 29th in Ottawa, under the guidance of Justice Marie-Josée Hogue, H-O-G-U-E. Now, the interim report in this foreign interference inquiry was supposed to be provided in February. It's been pushed back to May, and I think that's a good idea to delay that. It was in the Mass Casualty Commission, there was an interim report done fairly early, and it really had nothing in it. All it had in it was the material that was available before the inquiry started, which was already public. So if it was the case here that the hearings were starting in January and you do a report in February, well, that's not going to include anything substantive, just sort of procedural documents and expectations for the future. The same with the mass casualty interim report. So pushing it back to May will allow at least some assessment of the early evidence that is provided, and some guidance as to how long it may take and all these other things. So we'll look for that testimony to start at the end of January. Now, I talked a couple of videos ago about the requests for standing in this inquiry, and some parties have full party standing, which means they get to see all the documents, make submissions, question witnesses, and so on. Some have only sort of a modified standing, including the Conservative Party and the NDP. Conservative Party appealed that in a sense, so they requested a review from Justice Hogue herself. They didn't make an application to the court to have a judicial review take place. But that was refused. So the problem is, the shortcoming is that if you're not a full party, you don't get to see the documents that are not made exhibits. So you don't know what's been excluded from consideration. You only know what came into the hearing through somebody else's feeling that it was important enough to become part of the hearing. Different parties may have different views about which of the thousands of documents are important enough to make the inquiry hearing time itself. Now, Justice Hogue says, well, yes, but we don't want this to become political, and the Conservative Party has other options for getting that information. They can get it through legislative committees in the House of Commons, including the National Security and Intelligence Committee, which has access to classified information. All right, well, not quite the same thing. It's not as focused, and that also requires that those committees study the material in that same kind of way. Anyway, we'll see how it affects the inquiry, but it is going to affect how legitimate the inquiry is seen to be. Last one I want to talk about is the big story from down south. So you may have heard that now 2 states, Colorado was the first. Colorado the first and more serious, in a sense, of the two, and Maine was the other, who have declared that Donald Trump is not eligible to be on the presidential ballot in their states. Colorado did it through their Supreme Court, close decision, a 4-3 split decision. And then the Maine situation, that wasn't done through the courts, that was done through the electoral officer, who basically, though, relied upon the Colorado Supreme Court conclusion. So, former President Trump is not eligible to be on the Colorado presidential ballot, and the reason is the 14th Amendment of the U.S. Constitution, Section 3, which came in after the U.S. Civil War, which banned from office, and that's a defined term, banned from office anybody who shall have engaged in insurrection or rebellion against the same, which being against the country, or given aid or comfort to the enemies thereof. Okay, so this is the justification the 4-3 decision used, saying that, on January 6, 2021, that Trump encouraged or was part of an insurrection. Now, Trump's filed, his lawyers have filed a response, which I've reviewed, and I think it's going to carry the day. So it says, first of all, it's the first time the judiciary has prevented voters from casting ballots for the leading major party presidential candidate. He's way up in the polls, so it would be almost inconceivable that the judiciary would prevent the voters from being able to vote for the person who's leading in the polls. They also say that the purpose of the Section 3 amendment to the 14th Amendment was for people who engaged in, it was after the Civil War, it was a war, an armed insurrection, waged war against the country. But on the other hand, that hasn't happened since the Civil War. On the other hand, the United States has a long history of political protests that have turned violent. So there you go. I think this is the argument that's going to carry the day. This is a political protest, and I think the issue is, this has to go to the Supreme Court of the United States, and it has to happen quickly because the presidential election is this fall, this November. So, and that's quicker than courts usually move, particularly Supreme Courts. I think this argument's going to carry the day, though. This is a political protest. I think the court will say, yes, the president may have been negligent or reckless in his words that day, but this was at its heart a political protest, not an attempt to take over the country and see it through that lens. Concern also on the Trump team side is that this would be used as a template to disenfranchise voters across the country. And, really, I think that would be the case. I mean, it's already happened in Maine, as we've said. So the time pressure. The Supreme Court has two things now to deal with in the lead up to the presidential election. One is this thing out of Colorado, which says Trump is ineligible to be on the ballot because of the insurrection of January 6th. The second thing that's coming to the Supreme Court is this special prosecution request for the Supreme Court to quickly consider the issue of presidential immunity and whether the president, just by being the president, is immune from criminal prosecution during his time in office. They're immune from civil prosecution and civil suits for anything they do. I think, as I said before, I think the court is going to come down and say, well, if it's a political act, then it cannot be a crime as well. And there's some leeway there for the president. I think in this case, they're going to consider that the nature of the January 6th series of events was a political protest, not an armed insurrection, and that the former president will be eligible. Anyway, those are the thoughts on that one. So hopefully I was trying to, it's so much different down in the U.S. Just the court structure is different. The way that states have control versus in Canada, the provinces don't have the same level of authority over issues that the state courts in the U.S. do. In any event, that's sort of my summary of that. If you need some shorthand for what's going on down there. All right, well that's it for this week. I'll be up on Sunday night with the Sunday night show with Paul Palango and Jordan Bonaparte. So be tuning in there and be getting messages. Paul Palango doesn't take a vacation. He's been reading articles and digging into things all Christmas break and sending me emails, read this. So it should be a great show when we get back Sunday night. So until then and until next week, thank you everybody for watching. Thank you for listening, and we'll see you next time.